in session. Please be seated.
All right, welcome back, everyone. We are back in session for our final argument of the day. And again, I just want to express my gratitude to all the folks at UTC here and the lawyers who have made the effort to be here today. And Judge Tom Greenholz is really the one who put all this together, so I wanted to give him credit. It was those of you who just sat in on our luncheon, when he tells you he's kind of obsessed with all this, he is. It was about a year ago, wasn't it, Judge Hickson? He came up with this idea, and he's worked on it diligently since and pulled it off.
With the good help of about
with the help of
people.
his staff,
yes.
And our court clerk and offices. So anyway, with that, we'll call the last case.
Byron Hartshaw versus State of Tennessee.
And before your time, again, we've got students here, and since this is a post-conviction, maybe give a little bit of background on what post-conviction is to the extent that that doesn't mess up your arguments.
I can do that.
Thank you.
Thank you. Good afternoon, Your Honors. May it please the Court. My name is Autumn Bowling. I'm here for the appellant, Byron Hartshaw. I'd like to reserve 5 minutes of my time for rebuttal. This case arises out of a post-conviction proceeding in which Mr. Hartshaw has already exercised his direct appeal to this court, has now gone back to the trial court in its function as a post-conviction court, and has alleged instances of ineffective assistance of counsel by his attorney, who I'll refer to as trial counsel throughout this argument. And so where I want to start is that our entire profession is based on communication. Whether it's orally in court like we're here today, or we're writing something down and filing it, we're exchanging emails, text messages, our entire profession boils down to communication. And if we are not doing it effectively, if we are not responding, we are failing. Now I'd like to focus on, out of my brief, this would be issues presented numbers 1 and 3 is what I'd like to focus on. And the broad facts of this case are that the petitioner, Mr. Hartshaw, and his co-defendant were charged in relevant part with counts 1 through 2 of aggravated robbery with a deadly weapon, and counts 3 through 4 of aggravated robbery with an article fashioned to allow the victim to reasonably believe it was a deadly weapon. And so when the trial counsel reviewed the case, actually his co-defendant's counsel, Mr. Gindy, realized there were 2 items mentioned that could be alleged to be either the article fashioned or the actual deadly weapon. And that was both a gun and a hammer. Mr. Gindy filed a bill of particulars that Mr. Hartshaw's trial counsel joined in on. And so there was a hearing, and what this bill of particulars was for was to identify and ask the state to particularize and memorialize whether or not this hammer was supposed to be the deadly weapon alleged in counts 1 through 4, or if it was the hammer as well. Now, when they get to the trial court during this hearing, the trial court asked the parties to go ahead and discuss this, and the state gets up and puts its position about the hammer on the record. The trial court then, I'll say, mirrors that position back. And without objection, the parties are satisfied. And what the trial court says at that point is very important, and I would like to get to that in just a moment. But there's no real, I'm going to say there's no official ruling from the bench. There's no real resolution as to what this happened with this bill of particulars, whether it was actually dismissed, whether it was considered resolved, granted.
Was there even an order in the file or anything to that effect in the record that we'll find?
There was no order, Your Honor. This was all done orally. And so they gave their position, and basically what the trial court had said was, well, I think that solves it. Okay, everybody's happy, we'll move on.
And what was the position? What was actually said in court? We do have that. I assume we have a transcript.
And so the state's position was that, one, these were prosecutors who did not handle the court in sessions, so they were not actively involved in the case until it got here to this point in criminal court. And so the prosecutor's position was that it's not going to be the hammer. Just boiling it down as simple as possible. It's not going to be the hammer. It's about this firearm. It's about this gun that was alleged to have been seen. And this hammer is, they didn't say it was just a stolen item, but that's originally how
Well,
it was written.
it's a little different than that, though, counsel, right? Because didn't the state say, I haven't reviewed the preliminary hearing. I need to go back and take a look at the preliminary hearing. As I understand it now, the deadly weapon is the firearm. But the state didn't come out and say before the judge, hey, the firearm is the only deadly weapon, right? They left the door open to come back, isn't that right?
I would not agree with that, Your
Okay.
Honor.
How so?
This was that they got up and said, we were not the prosecutors who handled this. I actually think they did say we listened to the audio. I think, though, that they had not, either it hadn't been recently or something else had happened. I can't get into their minds, but they got on the record, made their position, and what I think is very important here is that the trial court said their position back to them. And I want to read what that quote is, because the state did not object to this. And so the trial court resolves it as, the hammer is not the deadly weapon that's being referred to in the indictment. It is, in fact, what appears to be or is alleged to be a handgun. So that appears to be means that he is referring and saying it's not the hammer that's the article that's fashioned. And that's really where this gets to, is counts 3 and 4. And
Was
so
the
when
bill of particulars, did it cover all 4 counts?
It did, and so there's actually this is somewhat in the record and somewhat not, but there was an original indictment where the hammer is actually, everything's kind of listed out in the indictment. And then there was a bill of particulars by, again, Mr. Gindy, the co-defendant's counsel. And then there was a superseding indictment that came out. And I checked with Mr. Gindy as well, because this motion and bill of particulars is not in the record, and it was not in Mr. Emery's direct appeal record, from what he told me. And so if I need to supplement the record with that, I can, but what I can tell this court as an officer of the court is that in reviewing the motion for bill of particulars that Mr. Gindy sent me, it did ask for counts 1 through 4.
But that's not in the record.
It's not in the record that I have been able to find, and he did not believe it was in Mr. Emery's direct appellate record as well.
So, counsel, let's assume that the state, and I'm not sure this is the case, but let's just assume that the state thought that it was entering into a stipulation at that point. Could the state have withdrawn the stipulation?
I do not think so.
I mean, it's irrevocably binding?
Pardon?
It's irrevocably binding? It's irrevocable? It's binding throughout?
No, and that actually, I think, gets to part of one of the issues that we've raised, which is that it wasn't in writing. So this all happens, and none of this is ever put in writing, not the court's order. All we have is a transcript. There's nothing, and that is part of our issue, is that trial counsel never even asked for this to be memorialized.
What else would have been memorialized outside of what was in the transcript?
Well, I would say that asking and saying, I don't think that this is resolved, Your Honor. I think what we need to do is have the state go ahead and memorialize their position in writing and respond to our motion for bill of particulars.
So if you're asking the trial court, though, to put down an order, what would the order say that is different from the transcript?
Well, I think it would have, I think it would say what's in the transcript. And again,
Okay.
I think that is
So we have the transcripts in writing.
We do, Your
So
Honor.
we know what happened there. So what would, I mean, one of the claims is that counsel should have gotten a written order separate from the transcript. What would the order have said that would have been different from the transcript?
I don't think it would have said anything different, but that's part of the problem, is that because it was never written down, when they get to the jury instructions later on down in the trial, nobody has a transcript just ready for this. And so what happens is that the trial court, I'm going to say, misremembers what exactly its ruling was or how specific it was, and that it agreed that the gun is in fact what appears to be or is alleged to be a handgun. It's not the hammer. The trial court was encompassing counts 3 and 4 in its ruling in the transcript. But when we get to trial and we're talking about these jury instructions, we have nothing in writing at that point. If we're standing live in the courtroom at that time, nobody has a transcript.
So what's the deficiency of counsel? Is the deficiency of counsel not being fully prepared to have what is in writing there at trial?
No, the deficiency is not asking for it to be memorialized at all and accepting just this oral, I would say, allowing the trial court to just say it's solved.
even though you can see the order would not have said anything different from the transcript.
Right, because when we get down the road, we don't have that in front of us. And what happens is that the trial court does in fact give a jury instruction. And this is, I think this is very important. And when I argued this, I actually put it on a PowerPoint to the trial court to emphasize what the trial court said at that point. When it granted the jury instruction on counts 1 and 2, it said, this is not the law, this is not the right decision, but I now have to protect your clients from ineffective assistance of counsel. And I think that's very powerful and very telling. And what the problem is that because there was nothing in writing, and we are all relying on our memories, and the state's getting up and saying, we had already withdrawn that, and that's the only thing that's really in writing, is their withdrawal on the email. And what happens is now the trial court thinks, well, I only have to fix counts 1 and 2. I don't have to fix counts 3 and 4 because the only thing that they asserted was that it was for counts 1 and 2. It's just the gun on counts 1 and 2. They didn't say anything about 3 and 4. But when we go back and look at the transcript, what the trial court said, and again, the state did not object to in what the trial court was rephrasing or paraphrasing as, it is in fact what is or appears to be or is alleged to be a handgun. There's nothing about the hammer. They are agreeing it is not the hammer in counts 1 through 4. And so when we get back to, we're standing here and we're talking about our jury instructions, and we're actively in the case, we do not have anything written down except for the state saying, I don't think that's the case. And then, which gets to the third issue of the brief, which is, or not the third issue, but...
Before we leave the first, can I ask a question, please?
Yes.
So the brief identifies the first issue as a failure to prepare a defense to the fact that the hammer could have been considered a deadly weapon or an article fashioned to believe that it could be. Is the entirety of that argument solely with respect to having the stipulation in writing, or are there other parts of the argument you're saying that counsel failed to do X, Y, and Z to anticipate or prepare a defense?
I think it is somewhat of a mixed bag, and I think what is complicated about this particular issue is that it becomes somewhat of a chain reaction. It all kind of starts out with, we went to this motion for bill of particulars hearing, we just let it, we didn't do anything else. We accepted what the court said, nothing was put in an answer, there's nothing official, there's nothing formal, we have nothing. Okay, maybe that's fine, but then we get the wrench, and the wrench is that the state very shortly after says, hang on a second, I'm going to take that back. And then trial counsel does nothing about it. And so when we talk about...
Is that accurate? Because trial counsel testified at the hearing that he received the email, received it from someone else. He researched it, which meant that he considered what was going on, and then based upon his research concluded that he didn't want to approach the court, that was kind of up to the state. So it's not like he didn't do anything about it, right? He received the email, he considered it, he researched the issue, and then made a judgment based upon his research.
In terms of, though, what was also revealed, though, at the post-conviction is that based on the fact that what he heard in court, that again, there was no order on, whether it's, I don't know if it's a dismissed bill of particulars or what exactly it would be considered in our record. But what he was left with was that he said, I didn't prepare a defense for it, even though he knew there was
What would the
email.
defense have been? So on direct appeal, this court considered the issue and said that the hammer is a deadly weapon. As a matter of law, it is. It's either in its use or in the manner of its intended use is capable of causing death or serious bodily injury. It's a deadly weapon. What possibly could trial court have done outside of the stipulation issue to prepare a defense against the hammer not being a deadly weapon? What could trial counsel have done?
Well, for the first thing, I think, is that sometimes we just have these unchangeable facts. They're facts beyond change in our case. And so what would have happened if then, let's say he did go to the trial court and said, hang on, we got this email, I need to know what this means. And trial court says, well, I'm going to let them withdraw it then. And they can use the hammer. Now he has to build his defense. And what I think the defense would be is, one, again, when you have a difficult task like that, you have to do more cross-examination. Again, getting into more of the credibility on that, more cross-examination.
On what point? On the hammer not being a deadly weapon?
Well, I think in terms of this, not being a deadly weapon, I think there is some argument to that about how it was used, how it was wielded. Because
I mean, this court concluded that it was.
Yes, Your
So
Honor.
already having that finding now in our global record that we know that the hammer is a deadly weapon, I mean, what other questions would he have asked? And is any of that presented at the post-conviction hearing?
Well, I think what he would have asked, or perhaps what I would have asked, going back again, I'm still arguing to a jury that has not decided anything yet, is that how, because there was originally the allegation seemed to be that the hammer was just a stolen item from the house. It may have been Mr. Emery's at some point, the co-defendant's. But that task would have then been, okay, I'm going to cross-examine my co-defendant because the co-defendant testified, which was another reason why Judge Sword, the trial court, decided to give a partial jury instruction on this. Because Mr. Emery got up and testified about the hammer. And if I was, I don't want to play, the Monday morning quarterback, but if I'm standing there, I'm going to have to talk to Mr. Emery and cross-examine him about, well, how are you using that? Did you pick it up? Where was Mr. Hartshaw when all of this happened?
Okay, so was any of that presented in the post-conviction hearing?
Pardon?
Was any of that presented in the post-conviction hearing?
No, Your
Typically in
Honor.
post-conviction law, when we say that counsel should have cross-examined a witness in greater detail, typically the law places the burden on the post-conviction petitioner to call that witness in the post-conviction hearing, ask the questions that should have been asked at trial, so that we have in the record what those answers would have been. Do we have that record here?
We do not, Your Honor. We did not call Mr. Emery to come down and did
Okay.
not call his lawyer.
Then that hurts us then to consider the theory that you're raising, does it not? Because it's not in the record that we have to consider?
I think it does make it more difficult, but I do not think it makes it impossible because the issue isn't necessarily that he failed to raise a defense, and it does become an issue down the line, how things have been different. But when I look at it, failing to prepare a defense for it at all, just because we may think that it's not a great issue when we're standing there in trial, doesn't mean we can just let it go by. We still have to try and do something.
But in post-conviction, though, we have to show that it probably would have affected the outcome of the trial, the prejudice prong, right? And so even if we were to agree with you that somehow counsel didn't fully investigate the defense, it's important to know what that defense would have been so that we can evaluate that defense in the context of the proof to make a conclusion then that the outcome of the trial probably would have been different. So what would have changed here in the trial if counsel had done more investigation, as you say?
Well, I believe that trial counsel would have then actually addressed the issue instead of letting it go by.
How would counsel have addressed the issue such that we may have had a different conclusion, a lesser included offense, an acquittal? How would it have changed?
I think it would have gone to additional questions about the credibility of the witnesses and the victim, as well as different questions to Mr. Emery, and all of this going back to, they did get several, they were acquitted on everything that had to do with a gun, with a firearm, and where the firearm is only alleged. And so obviously there was effectiveness in what they were doing. And so I think when you just addressing it the same way they did the hammer and actually bringing it up, or the same way they did the gun, just actually addressing it, I think that would have been the difference, because we obviously had a jury that paid very close attention. And we see that especially when we see the two jury questions that come back, and they're very perplexed by this hammer. And they're probably, I would submit that they're perplexed by the hammer because there wasn't much on it. And there's nothing on it because trial counsel decided, I'm not going to get anything in writing. I'm going to ignore this email and not act upon it to my client's detriment. I'm going to essentially hope for the best and hope that there is a jury instruction down the line.
So if there wasn't much offered by the state in terms of the hammer being a deadly weapon, what more could trial counsel have done? Yeah, no, you're fine. I understood you to say that the state didn't offer much evidence on the hammer and that the jury probably was perplexed. If there wasn't much evidence on the hammer, what more could trial counsel have done?
I think it's an argument. In your closing arguments, you address it, and you didn't hear anything else about this hammer. And so, again, it's harder for me to place myself right there, but there was obviously some effective counsel happening. There was some defending going on. The problem is that it was only partially. The trial counsel completely ignored the fact that he knew the state was going to try to use the hammer. And what's even more perplexing, which kind of goes to the second issue presented, is that the state immediately starts talking about it in opening arguments in a manner that would suggest we're going to say during this trial that the hammer is a deadly weapon, or the hammer is the article fashioned to look like a deadly weapon.
So in the post-conviction hearing, and you'll forgive me about what's actually contained in the proof, At the post-conviction hearing, was trial counsel asked about why he or she did not argue more specifically about the hammer in closing argument?
I do not believe we got into it that far.
Okay.
And part of that.
So if there's no testimony from counsel about why we're not arguing a question that has almost no proof on it, how is it that you overcome the barrier or the presumption of reasonable representation? How do we overcome maybe the hurdle that this was a strategic call if no one asked trial counsel whether it was or whether it wasn't?
I think going back to what Strickland requires and what the overall test is that we have to, what is reasonable in our profession and what is, I cannot imagine any scenario, even this one, where it appears as though it's struggling to say, well, how could it have been different? How can it ever be reasonable in our profession that we ignore an email that specifically tells us the state is changing its theory of the case on us? I cannot, there is no way that that does not affect the trial in some way.
Well, help me with this. I don't want to, I know judges have other questions too, but one more question on this. If it is true that the hammer isn't playing that big of a role in the trial, if it's true that by the time we get to the close of the trial, the jury's perplexed about why we're talking about a hammer, what is it the trial counsel would have done? I think maybe that's the hurdle that you could help me with. What more could trial counsel have done at that point? What does it matter if the stipulation wasn't entered? If at trial there's not much proof on it, what more could trial counsel have done?
I think what trial counsel can do is address it, and you can't just ignore it when they're arguing it. You can't just concede that to the jury. And I think by not addressing it at all, you're implying to the jury, it's the hammer. You know, like I have nothing to go on. I can't do anything else with it.
Thank you.
So if I could go ahead, I'll pass it on to my friend.
Thank you. Judge Ayers, thank you very much.
General.
May it please the court, Catherine Redding on behalf of the state. The petitioner has failed to prove his claims of ineffective assistance of counsel. First, petitioner has failed to prove that trial counsel was ineffective for failing to get a written order from the trial court. First, he's failed to prove trial counsel was deficient. Although counsel did testify at the post-conviction hearing that he did not get a written order, petitioner never followed up on that testimony. We have no information in the record as to why counsel didn't get a written order. And as a result, there's no proof indicating whether that was a strategic decision or whether it was just a failure to act. And without proof in the record, the petitioner can't overcome the strong presumption that this court affords to counsel's decisions, the strong presumption that counsel's decision was a reasonable strategic decision. Second, the petitioner can't establish prejudice. So in this situation, a written order, as far as I can tell, would only have said that the trial court found the motion for bill of particulars moot, given the prosecutor's statement. If you look back at the record, what the prosecutor says is, it's my understanding based on the preliminary hearing, I wasn't there, but it's my understanding that it's just the gun. There is no stipulation that the state is only going to rely on the gun. The prosecutor makes it clear, I'm just going off of memory here, and then immediately follows up after the hearing with an email to defense counsel saying, oh, I've gone back and looked at it again. It's clear from the testimony at the preliminary hearing that the hammer is also involved as well.
So it sounds like your friend on the other side, though, is suggesting that trial counsel thought that there was a stipulation. So even if from the state's perspective there actually was no stipulation, in fact, it appears, at least the argument is that trial counsel thought that there was. Isn't it incumbent then upon trial counsel then to more formalize what is going on here? So it's not just an order denying the bill of particulars, but in fact is a stipulation entered into the record that could be enforceable later? Isn't the failure to do that not evidence of deficient performance?
I don't think so, and I think that that kind of goes into the next issue that counsel touched on but didn't really dive into about the claim that defense counsel ignored the state's email. And I guess just to wrap up the first claim about no written ruling, as to the prejudice claim, I am unable to determine what a reasonable probability that the trial outcome would have been different had we had a written order that says this is moot. as the court kind of hinted at, an oral ruling with the transcript carries just as much weight as a written ruling.
Yeah, do we have everything we need in the record to determine that issue?
Yes. We have a transcript of the hearing. We have the email that followed up. And I mean, given the timing, I'm not sure that an order saying a motion for bill of particulars is moot because the state made this one announcement, given that they followed up and given how much time there was before trial, that having a written order memorializing the oral ruling would have changed how the trial would have resolved itself. But in any event, to the extent the defendant is claiming that counsel was ineffective for ignoring the state's email, and I mean, to your point, did trial counsel have an obligation to act, to do something?
To memorialize an understanding that trial counsel thought may have existed?
Yes. I think that's an option. But the claim is trial counsel didn't do anything, and that is not supported by the record. Trial counsel did not ignore the state's email. He read the email. He went and did research. He concluded that the state had made the statement. The state had made this, had announced in court that it was planning to rely on the gun. And if the state wanted to change its mind and rely on the hammer, then it was up to the state to bring that to the court's attention. This decision was reasonable given that this stipulation was favorable to the petitioner. I mean, the decision to not really bring the email to the court's attention, that is a decision. That's not ignoring the email. That's a decision. And given the fact that Mr. Emery was seen on video holding a hammer in the immediate aftermath of the offense, I think that it can be counsel made a decision not to bring it up and to hold the state's feet to the fire when it got to trial and force them to basically go along with its first announcement.
Risky proposition.
Yes, but.
So, in a risky proposition, would there have been a duty on the part of counsel to have a plan B? And that is, I'm not going to raise this and hope I can skate on it, but plan B, if it comes up and the state tries to withdraw it, the trial judge allows the withdrawal of what I thought was a stipulation, now I have my defense that's been prepared. And so what I understand your friend on the other side to say is that there was no backup plan. There was no defense that was prepared in case the trial court changed its mind or the state backed out. How is that not evidence of deficient performance?
Well, I think that we have some initial problems with that particular claim, the petitioner's claim that trial counsel did not prepare a defense. And the first is that he didn't formally raise that in his post-conviction petition. He didn't litigate it at the post-conviction hearing, and the trial court didn't rule on the issue of whether trial counsel was ineffective for failing to prepare a defense. So if we move, it's waived, but even if we move past waiver, the petitioner didn't establish sufficiency. And the reason he didn't establish sufficiency is because he didn't elicit any proof on this at the post-conviction hearing. What was elicited was a comment from counsel that he didn't prepare a defense in that he didn't research whether a hammer can be a deadly weapon or prepare a defense to, quote, attack the concept of a hammer being a deadly weapon. So that's really the only evidence that came in at the post-conviction hearing, and that is rather specific. It's not broad enough to get to the greater concept of preparing a defense for the hammer. And counsel did testify that his defense was to basically hold the state to its quote-unquote stipulation. But I think that even if, as to part plan B,
Right.
counsel didn't articulate this, but we can tell from the record that counsel did prepare, his defense for the gun was broad enough to encompass a defense for the hammer, because given that you have video of Mr. Emery in the immediate aftermath of the offense holding a hammer, the way that you say the hammer wasn't a deadly weapon, it was that, not that it is not as a concept a deadly weapon, but that it was not used as a deadly weapon. And the way you attack that is by attacking the witnesses, which was the defense for the gun. And the counsel testified about how the steps that he took to establish a defense for the gun, which was based on attacking the witness's credibility and establishing that they, defendants, basically had an open invitation to enter the victim's residence. So if you establish that they have an open invitation to enter the residence, and then you establish that they're not credible, such that the jury can't believe their testimony that they had a gun, that also takes care of the hammer, because they don't have a gun. If they're not credible, If jury can't believe their claims that the defendants had a gun, they can't believe their claim that they had a hammer. But that also is just trickier by virtue of the fact that there's video evidence of a hammer, whereas there's nothing for a gun. And to the extent that the defendant saying that trial counsel was ineffective for not cross-examining witnesses more about the hammer, that is not something that was in the petition, litigated at the hearing. It's not something the trial court ruled on, and I don't believe it's actually in the briefing. The brief seems to focus more on, it mentions the failure to conduct the legal research on the hammer issue, but doesn't really get into that. But in any event, the petitioner can't prove prejudice either, because as the court has discussed, had counsel done research on whether a hammer is a deadly weapon, it would have found plenty of cases that say a hammer is a deadly weapon. And he can't show a reasonable probability that the outcome would have been different and that he would not have been convicted of aggravated robbery had counsel changed the theory, because the petitioner could have been found guilty of aggravated robbery based on the gun, despite the fact that he was not convicted of the possession. That's a different analysis. It doesn't really affect whether there's a reasonable probability a jury would have just rejected both the gun and the hammer. So unless this court has any further questions, the state asks this court to affirm the judgment of the trial court. Thank you.
Thank you. Does she have any rebuttal? We'll give you 1 minute for rebuttal. I think you used all of your time before, but.
Thank you.
Yeah, answering Judge Greenholtz's questions. Thank you for doing so.
So just a few things. First, in asking him to memorialize it in some way, that doesn't just have to be the court doing an order of what happened there that day. It also could have been standing there and saying, I am asking the state to go ahead and particularize in writing what it wants to do. That is an option as well. And to say that it is an option to memorialize what happened and what the court said, I don't think that it reasonably can be an option, because if you get a favorable ruling as a defendant in your case before trial, to have something not come in that could harm your client, to not get it memorialized and not have that formalized and ensure that it is rock solid for you, there is no way that is an option. As to holding the state to its stipulation and what the trial court did, again, if it would have been in writing, the court would have had to enforce again that what the court said the state's position was, that the state did not object to, is that the item that appears to be a deadly weapon or is a deadly weapon is the gun. It's not the hammer. And if he would have done that, then counts 3 and 4 would have also had a jury instruction. And again, by not memorializing it and getting that favorable ruling memorialized, he caused prejudice to his client, because his client ended up getting, because the hammer could be considered on counts 3 and 4, they convicted him of the B felony. If not, I think it stands to reason that when they acquitted on a lesser, on the B felony in counts 1 and 2, found him guilty of a Class C felony, if he was only found of a lesser included on counts 3 and 4, he would not be serving the full 15 years, and it wouldn't be the 85% either. So he is certainly serving more time because this instruction was not given on counts 3 and 4. And that did not happen because there was no memorialization. There are no other questions. Thank you.
Thank you.
Thank you.
Thank you again for the attorneys, everybody for being here today. I'll just say on behalf of the court, it's absolutely been a pleasure to be here in this beautiful environment. We appreciate all the work that everyone at UTC and the AOC and our court clerk's office, and especially security. They've taken awesome care of us today and led us around this beautiful labyrinth of a library, or we would have been lost and not have made it. So anything you fellows want to add?
I think it's wonderful. Thank you all for appearing here today. Judge Ayers had thanked the university at the beginning this morning, but I love this place. It's a obviously I'm a graduate of this university. My wife is a graduate of this university. And it really has come through today, not through the work of a couple of individuals, but of scores of people. And so thank you all for attending today and making this a success. I hope that we've brought a little bit of the court into the community, but the community certainly has, we've been enhanced by your participation today.
I'll follow up. It has been a terrific experience, and I want to thank everybody. We usually don't applaud at the end of court, but I think in this instance, it would be appropriate to thank everybody who did this, and especially
Yeah.
Judge
Judge
Greenhouse
Greenhouse.
for doing that.
And for the students, the lawyers have agreed to stay about 10 or 15 minutes and answer any questions you may have of them. The questions could be about the case. Questions could be about their jobs, what they do. It could be about going to law school. It could be any of that. So take advantage of that opportunity. And to our lawyers who've been here all day, thank you all very much for agreeing to do that. You're a critical part of this, and so thank you all. Okay.
All rise.